I'm really pleased to be here, and I want to thank Carrie and Cindy and everybody involved with this program for having me come and moderate what is an extremely distinguished panel. So just a little bit of discussion about how the rest of the afternoon is going to go. We're going to have a panel here that's going to focus a little bit on Microsoft versus Motorola and the sort of legacy of that case, primarily specific to patent-related issues. And then the second panel is going to sort of take it up from there and talk about sort of the current and future iterations that we're seeing, or movement we're seeing in the standard essential patents world, with some antitrust and other aspects involved as well. So that's sort of how we're thinking of the panels. They may overlap a little bit, and they may not go just like that, but that's sort of the idea. So we're really happy on this panel to have three distinguished speakers, all of whom have unique perspective on the Microsoft versus Motorola case, as well as standards essential patents more generally. So I'm going to introduce them in the order in which they're going to go. We're going to go through each of them. They're going to have about 10 minutes each or so, and then we'll have a more general discussion with question and answer at the end. So Cynthia Dahl is the Practice Professor of Law and Director of the Detkin Intellectual Property and Technology Law Clinic here at Penn, and a treasured colleague of mine, as well as others in the school. She's the founding director of that clinic, which is one of the most innovative clinics in the United States that deals directly with how to transact around intellectual property rights, patents, trademarks, and copyrights primarily. So in that sense, she specializes and does research on business applications of IP, and is indeed something she's dedicated an entire career to. Before joining us here at Penn, she was a senior IP counsel at True Position, which was an international wireless location company in which she engaged in many IP-related transactions, some of which I'm sure were related to standards patents. And then prior to that, she was an IP litigation associate at Holland & Hart, and before that at Penny & Edmonds. So she is, well, we're looking forward to hearing from her. Andy Colbert is a partner at Perkins Coie and has 30 years of experience strategically guiding technology companies through complex IP matters. He is the former Associate General Counsel in Microsoft's litigation department, and was heavily involved in the Microsoft versus Motorola case. In addition to that case, he's been involved in U.S. Supreme Court cases dealing with the frameworks for getting worldwide damages for infringing U.S. patents, and redefining the law of patent damages before the Federal Circuit. So lots of decades of experience in IP, and specific to this particular case that we're interested in today. Kirk Dailey is a Senior Vice President of Business Development at the Marconi Group, which is a group that is solving problems and addressing complex business challenges surrounding patent licensing issues. He's got 20 years, more than 20 years experience in IP management and licensing. He led the patent transactions group for Google, where he did a lot of strategic cross-licensing, community-based licensing solutions, and worked across a variety of companies, including the sale of Motorola Mobility to Lenovo. Prior to joining Google, Kirk was also at Motorola, so he was also involved in this particular case, albeit from the other end of the spectrum from Andy. So you note that they are sitting separated on the panels. We've made sure that it's all good. And so he is, we're excited to have him here and hear both his perspective in terms of the licensing aspects of standards essential patents, as well as his experience with the case. So I'm going to call now on Cindy for about 10 minutes to talk about her, well, she's going to introduce some of Microsoft versus Motorola, as well as her particular project.
Thank you, Polk. I can't tell you how delighted I am to be here today. This has been a major focus for the past 2 years of my life, actually. I think I know more about this case than any of the cases I was called upon to talk about, called to talk about in law school. So I wanted to give you a brief background to my involvement with this project and what brings us here today. So Carrie gave a lovely introduction to why we're here, and I just wanted to say thank you to NIST for having the vision and for supporting us in bringing this project to more law schools, because my experience in practice taught me that standard essential patents was an incredibly important area for a technology lawyer to know about, but yet was not really covered in law school. I had never certainly learned about it in law school. So I had already brought it into my class, but thought that I actually wasn't teaching it very well. So when Kerry came to me and he had the vision to say, why don't we do something together, and can you develop a module about standards essential patents, I was delighted to join him. And this has been a wonderful, long but wonderful journey that's given me the opportunity to work with Carrie, for which I'm very grateful. And I'm also very grateful that I got to meet wonderful people through the process. I traveled to Seattle and got to interview Andy Culbert and Steve Fortney, the clerk to Judge Robart, who deepened my understanding and gave me much more nuanced understanding the Microsoft v. Motorola case. And then, of course, Kirk Dailey came to visit us here at Penn, and I got him on tape, and then this morning, Judge Robart as well. So please avail yourself of the resources that are at the website. A lot of time and effort went into them, and I hope that they're helpful to those of you that teach in this space. As Carrie mentioned, there are four course modules. Mine is the last, and today we're celebrating the birthday of the website. So why was I so excited to work with this project? I already talked about the first issue. Interoperability standards, I think, really deserve to be in this project because they are so important to this area of the law, to patent law, to technology law. I also thought that this was an opportunity to present some interesting things. First, I think it, as Judge Robart alluded to, presents some really interesting tensions between the rights of individual companies and then the rights of the commons. And so I try to bring that out when I'm teaching this module in the class. And I think it's also interesting because it's increasingly showing up in our news at this point, news reports. Thank you to Apple v. Samsung for sort of introducing the world to patents and to standard essential patents in particular, and these injunction issues that we're going to be discussing a lot today. But then once I came in on the project, I had to choose a case to focus on, and I want to talk briefly about why I love this case so much and why I chose it. First, again, I thought this was something that would resonate with students. Everybody knows about the Xbox, everybody knows about Microsoft Word and Android, and so I think the subject matter was, of interest and already introduced to our students. Also, you can get really, really technical when you talk about standards, and the standards that are involved in this case actually are pretty straightforward as far as standards go. Everyone's heard of Wi-Fi, uses Wi-Fi, encryption technologies, and video compression technologies, and so I thought this was a good candidate for that reason as well. Of course, we've heard a lot about why this is such an important case, and so I thought, of course, we should be discussing an important case. And it also brings up sort of at least 3 distinct questions that I go through in the teaching module. Of course, the royalty calculation is at the base of this case, but it's also got really interesting contract issues, and of course, there's the issue of the injunction, and so it's a vehicle to introduce all of those concepts. It also, if we're getting sort of into the weeds here a little bit, raises some additional critical questions. First of all, what's the role of the standard setting organization in developing FRAND rates? And that's clearly a hot issue. Thinking about IEEE, we may see more of that issue. So I think that was important to bring up. There are also all of these valuation methods. You heard about bottom-up, we heard about top-down, but there's also incremental value, ex-ante valuation. Really, how should we be thinking about pricing standard essential patents? And I think that that's still an evolving issue and is, as Judge Robart said, extremely fact-based. So we'll see more about that question, I'm sure. Of course, hidden in this are also some questions about our royalty base. Should this be based off of the total product or off of components? And are we talking about a percentage of an end product price or just a flat fee? So there are questions about how to structure this royalty. Hold up and hold out comes up in all of these cases. Hold up meaning that the plaintiff is holding up the rest of the world until they get the price for the license that they want. Hold out meaning that the licensee just stays and stays until they get until they never get the price that they're willing to pay. So these issues also are in this case and are really important to standard essential patent cases. Injunctions, of course. Then I thought, as I was thinking about being a practicing lawyer trying to represent a licensor going forward, how would I recommend that they go about offering a FRAND rate? Out of this case, I wondered if licensors might be a little bit frightened, about being hauled into court no matter what they said. So I thought that's an interesting question to pose to students that are ready to enter practice. And of course, there's the issue of dispute resolution. Was this a good use of court time, or are there other ways that people can resolve this? And I thought that this was a good vehicle to talk about that. So I'm going to pose a few questions that I expect that we will get into and hope we will get into today. First, in this first panel, I expect that we're going to hear more about the forces that led to bringing this case to court. Forces that might have been related to the parties or unrelated to the parties. Then I hope that we address what questions about licensing were unresolved at the beginning of the case and necessitated bringing a court in to resolve the dispute. And then, of course, I know we're going to be talking about what questions remain at the end of the Microsoft v. Motorola adjudication. And I know we're going to hear a lot about the role of Microsoft v. Motorola as cases are going forward. Then, when we turn to panel 2, I hope that we can really drill down on the questions that remain, especially as concerns a lot of antitrust issues, SEP and injunctions, what's going on with the SSO guideline documents, and what the role is of governments in trying to control the use of standard essential patents.
All right, thanks, Cindy. So you can either stay there or you can go up to the podium, your choice.
Okay, is there a clicker that
There's
I
a
can use
clicker,
here?
yep.
So I think maybe I'll just stay seated.
Sure.
Okay, good afternoon, everyone. First, I want to give a big thanks to Cindy and Polk for asking me to come speak to you on this topic. This is something that I took up a few years of my life. I'm happy to come talk about it and share a little bit of what my role was in this case. I also, before I spent 17 years as the Associate General Counsel at Microsoft, I headed up Microsoft's patent litigation docket for 17 years. Before that, I was a partner at the firm of Drinker, Biddle, and Reith right here in Philadelphia. So I spent 15 years at Drinker, Biddle and lived in Philadelphia, and I'm really happy to be back. It's I've adopted Seattle as my home, but Philly's still my second favorite home. So I'm happy to be back and talk to you today. Okay, so first thing I wanted to do here is for those of you who might not be totally conversant with all of the details of standard setting and the law around standard setting and how this has evolved, is start with a little basic sort of primer about just the litigation of FRAND cases and how they come about. One thing that's interesting about FRAND is that it's sort of the intersection of three different areas of law. You've got contract law, as Judge Robart mentioned, our case was a contract case. You've also got patent law in here in the Federal Circuit, in the D-Link case, addressed it that way. But it's also has antitrust issues involved too in the Third Circuit. in a groundbreaking case a couple of decades ago, addressed this issue of standard essential patents in an antitrust way. So you've got this intersection of these three areas, and so part of what my job was to navigate a path forward, and so you almost had a choice of how to go, just a tactical choice. How do I approach this? Do I approach this as a defense to a patent case? Do I approach it as an affirmative antitrust case, or do I approach it as a contract case? And the contract case itself is a little bit unique, a little different, because Microsoft, my client, was not a party to the contract. We were a third-party beneficiary, arguably, of a contract between the licensor, in this case Motorola, and the standard-setting organization. And that contract itself really is not a classic document that even says contract on the top of it and gives you all the rights and obligations. That ends up being effectively what are called a letter of assurance, where the licensor sends a letter in and says, we hereby promise and agree that we will make our patents available on fair, reasonable, and non-discriminatory terms. So this was all a little bit new when this case first came up. So standards and how standards work. So I just at a very basic level, this is an example I often use to describe what the standard process is all about and why it's so important. So here you see an example of three different standard technologies. You've got a type of electrical plug that works in China, a different one that might work in Europe, and a third one that works in the US. They're all perfectly fine technologies. They all do the same job, but they are somewhat unique, and they only work where they work. If you are a patent owner, if you have the patented technology on one of these standards, then the value of your patent depends on whether that standard is chosen. It doesn't really matter how great the technology is if you've got a patent on the three-prong plug, if the local jurisdiction decides to go with the two-prong rectangular plug instead. Now your patent on the three-prong plug, as good as it is, the value of it sort of disappears. So the issue that you're dealing with in a standard setting context, where there are patents that are involved in the standard, is the power of the selection of the standard. Once the standard is chosen, then the people who have patents directed to that particular implementation, those people have potentially enormous power. If the standard's not chosen, then the patents on that technology drop dramatically in value. And so that's what gives rise to this dispute, because there is a lot of research and development that goes into the creation of standards, and it happens in our particular area here, the smartphone area. The same type of thing happens. For example, it's harder to illustrate, but if you think about 4G technology, if you buy a cell phone, if you want a phone that has 4G technology or LTE technology, that wasn't always a given that would be the standard, that would be the technology. LTE actually was in competition with another technology called WiMAX. It was in competition with a technology called UMB, and people did not know who was going to win. So here we had a situation where Motorola had patents that they had declared to be essential to two different standards, the 802.11 Wi-Fi standard and the H.264 video standard. So how did we come about with our dispute with Motorola? That dispute began when Microsoft brought a patent case against Motorola having to do with Motorola's use of the Android operating system. So Microsoft is an operating system company. We sold the Windows operating system. We sold Office products. And Microsoft had a problem. This is going back 10, 15 years or so, when Microsoft's #1 product, the Windows operating system, started to compete with operating systems that were offered for free. So the first one that we confronted back in the day was Linux, and we had some discussions internally. How do we compete? We build a product, we invest in a product, we sell the product. How do we compete with a product that's offered for free and maybe offered by companies that have a business model that's not based on selling a product, but as an advertising-based model so that they can offer the product for free? How do you compete with that? And one of the things that we concluded was, well, it's not really a free product because it uses intellectual property. So if you take the Android system, even though it might be free in one sense, it's not really that free because it uses intellectual property, and we concluded it uses some of our intellectual property. So we began a licensing program where we started to license the Android system. We could not conclude a license with Motorola, and so we filed a patent infringement case. So Motorola responded, as I told people internally that they would. I said, you know, if we do this, if we sue them for patent infringement, it's a pretty good chance they're going to sue us for patent infringement too. That's just the way that works. So this is just a pictorial example of the standard setting process. And the reason that the FRAND obligation arises, the FRAND commitment is there to prevent companies from having excessive power when they go to assert patents that are declared essential to a standard. Okay, so I want to get to the actual dispute between Motorola and Microsoft. And I want to fast forward to the letter that we got. So we had Microsoft sued Motorola for patent infringement. And as we expected, Motorola responded with a threat of a lawsuit against us for patents. So this was a copy of a letter that we received back in 2010. We had just sued them. They then responded with this letter. It's from Mr. Dailey. You're going to hear from Mr. Dailey in a bit. It was addressed to one of my colleagues, Mr. Gutierrez. He sent it to me with a typical request from a client, which was along the lines of, now what do we do? So in this letter, what Motorola was saying was that they had a group of patents that they had declared essential to the two standards, the Wi-Fi standard, the video standard. They attached an exhibit to the letter, 52 patents. They said that we needed to take a license to these two and that they would give us 20 days to decide how we wanted to respond. The key part of the letter for me was the demand that Motorola was making based on these standard essential patents. So I've blown up the part of the letter here, but if you read the key aspect of it, what they were seeking was a license of 2.25% based on the price of the end user product for all of the products that incorporated these standards. So all of our products, all of the Microsoft products that incorporated the Wi-Fi standard and all of the products that incorporated the video standard, video compression standard, they wanted 2.25% for all of those products. So in September, October 2010, I got this letter forwarded to me, and I read that, and I did a real quick back-of-the-envelope calculation to determine, well, how much money does that mean? What does it mean to have 2.25% calculated on the end-user product? So it looked like conservatively they were asking for $20 billion in past damages and an ongoing royalty of $4 billion per year for these products on the standard essential patents. Now, if it's a standard essential patent, it puts the licensee in a bind because you sell products that comply with the standard. You advertise that they comply with the standard. You wouldn't sell the product if they didn't comply with the standard. So we admittedly complied with the Wi-Fi standards. We wanted to, we tried to. We admittedly complied with the video standards. And now we were faced with what looked like an imminent patent case in which the damages were going to be astronomical. And my client was asking me, what do we do? So no case of this sort had really come up before, but in looking at the letter and knowing and understanding that there was a FRAND commitment, an obligation to license patents on reasonable and non-discriminatory terms, it occurred to me that, well, they can't make this demand and be reasonable at the same time. They have an obligation to be reasonable. This, I thought, arguably was not reasonable, and therefore we had what could be a breach of contract claim against Motorola. So that's what we did. On the 19th day following the receipt of this letter, we brought the case in Seattle, seeking a ruling that the claims were unreasonable. So I think I'm going to turn it over to Kirk and let Kirk take it from here. But that's just in terms of how the case began. That's how we got to the filing of this case and why it came up. I will say that I think Judge Robart sold himself short, understated significantly a number of the things that he did in the case that truly were groundbreaking and that other people are now taking for granted. But back then, this case had never been, a case like this had never been filed before, and so you didn't know exactly how this would unfold. But a number of issues, such as even the entitlement to relief as a third-party beneficiary, even that question was raised in our case, and that was one of the questions that Judge Robart resolved. And I think a huge number of issues of that sort in all of the later cases really have built on the work that Judge Robart did in that case. So with that, I'm going to turn it over to Kirk and let Kirk provide the Motorola perspective of where this case began.
Sure. So thank you, Andy. And thank you, Polk and Cynthia, for having me here and speaking. Much like Andy, I spent several years of my life dealing with this issue while I was at Motorola and then Google as well, because it carried on after that. I'll just give you a background from Motorola's perspective, where we were at versus what you heard from Andy. You know, at Motorola, we were in the midst, it was October of 2010, and we had already told the marketplace that we intended to separate the company into two in January of 2011. So 2 months from when we were about to separate and go into a publicly traded company that was just the mobile phone manufacturing division, which was struggling financially to exist. So we were very preoccupied in how do we separate our assets and how do we carry on these two different companies. We also had a very long history, 20 plus years of licensing wireless technology in the communications space. We had licensed every manufacturer of mobile devices, and mainly that was focused on the cellular standards, which are different from the video standards and the Wi-Fi standards. But as smartphones were evolving, we continued to develop our licensing program to include the wireless standard, the Wi-Fi standards, and the video compression standards. But it wasn't as developed as the 20 plus years of licensing in the cellular space. So that's where we were. And it actually, it's kind of comical because at the time that we were busy dividing the company into two, we were also preparing for litigation against Apple. And we were just really waiting for the right ITC judge to show up so that we could file it, because they rotate through the judges, and we thought there was a good judge. So we were waiting for one more case to be filed, and then we were going to file the Apple case. And I was in a meeting actually with Ericsson that day, a Friday afternoon, and the case that we were waiting to get filed so we could file our Apple case was Microsoft suing Motorola in the ITC. And so on Friday we were sued by Microsoft, and then we had to meet on Saturday as we were spinning the company into, out, and our head of strategy said, there's no way we can go public and be in litigation with two of the largest, most profitable companies in the world. But we did. We sued Apple on Monday. And so we ended up in litigation with Microsoft and Apple at the same time. And from a product perspective, we had looked at different operating systems because smartphones and smart operating systems were just becoming of interest. And we had dabbled, we had worked with Microsoft actually early on in their smartphone products. And we also were dabbling with Android products from Google, and we were looking at, I think it was Symbian operating system that Nokia was doing at the time. And we decided strategically that we could only do one of these. And it wasn't necessarily based on cost, as Andy was saying. We thought the superior operating system was Android and Google. So we chose to go only with the Android operating system, which may have prompted, I don't know what prompted the litigation from Microsoft, but that's where we were from a company perspective. And then we were sued like we talked about in October of 2010. And Microsoft and Motorola actually met after that litigation was filed. And we had a very cordial meeting with Horacio. And Horacio and their general counsel said, we sued you, and we want, dollars per unit for every Android device that you ship. But we understand Motorola has a portfolio of patents, and we probably owe you money for those patents, but you need to put them on the table. And so that was our meeting that we had sometime between this letter, whenever the letter was sent, between when Microsoft sued us and then when we sent our letter. So we went back, and we weren't preparing for months to sue Microsoft. We hadn't thought about Microsoft. We hadn't had any conversations with Microsoft. So we said, well, what do we have? Well, we have standard essential patents. Like Andy said, they advertise compliance with these standards. We have the patents already mapped to the standards. We have a licensing practice. And so there was a lot of internal debate about what that letter should say. And we called it our initial offer, not a demand letter, as Andy indicated. But we had a long history and many, many agreements of 2.25% of the end unit price, but it was all for mainly cell phone manufacturers, so Nokia, Ericsson, BlackBerry, all those companies. So we didn't have, we knew it didn't quite fit Microsoft's model. They sold the end user product, the Xbox gaming system, so it kind of fit that one. But their operating system software for PCs, it wasn't really their product. But we felt, we didn't have any case law that explained what we should do. And so we went with our standard opening letter that we had sent to many, many companies before, which is we offer you a license at 2.25%. So we were hoping to have a negotiation with Microsoft, as we had indicated, that we would send them these offers, because FRAND, you can't sue for, we couldn't just file a lawsuit. We had to offer them a license in order to file a lawsuit. So it's one of the requirements of FRAND, or at least from our perspective, we had to do that. So we sent them a letter, and then we also had other patents that we put on the table as well and filed litigation, but we had to get that letter out first. So, but we were very surprised by the second case, the contract case, which is the discussion here today. We were surprised to be receiving it, as opposed to receiving a phone call and having another meeting and talk about, what the appropriate royalties should be paid for by Microsoft and what Motorola should pay. So that's kind of how we got into the situation. Do we want to talk about, you want to open it up now, or how would you like to?
Sure. You know, and it may be that a way to go would be to open it up to questions, and then we can have sort of an iterative discussion. We can talk about how the case unfolded. It was filed in the fall of 2010. One of the innovative things that Judge Robart did was he broke the case into two trials. The first trial, he concluded that you could not know whether an initial offer was or was not FRAND unless you first knew what FRAND was. And so we had a non-jury trial to determine what the FRAND rate and range actually was. And then following that trial, we had a second trial. This was a jury trial. And in the jury trial, the question came down to, was there a breach of the covenant of good faith and fair dealing by offering the license that was offered in light of what the court then already had determined was the appropriate FRAND rate or range. So you determined, the court in two steps. Number one, what is the right FRAND rate or range? And then two, give that range to the jury and pose the question, did it breach the covenant of good faith and fair dealing by engaging in this offer in that way? And so then we had a jury trial in Seattle and had that verdict. There's a lot happened in between and afterwards, but it may be that the way to go would be to open it up to questions.
Sure. So we have about 30 minutes now to have a conversation. I have a few questions I want to ask. I mean, one of the things I do want to ask the two of you from the outset is, did you think at the time that this was going to be a really important case? Did you know sort of the impact it was going to have at setting this sort of landscape for SSO litigation or SSO-related litigation for, the decade after? And if so, what was it? Like, what was it that sort of led you to believe that this was going to be a particularly important case?
So I can answer that. I mean, I think the short answer is no. I like a lot of things that happens in litigation, a lot of what you're doing is you're trying to survive into the next day. And so we approached it from the point of view of this would make sense as the way to go, and how it would ultimately unfold wasn't clear to us, but we knew there would be some fundamental legal questions, third-party beneficiary law, the legal question over the worldwide license, the letter that Motorola sent, the patents that were attached, the list of patents were patents for all over the world. So what made this case already a little bit unique was we were looking for a rate that was a worldwide rate, not just a U.S. patent rate. So there were lots of issues of that sort that maybe if I'd been smarter, I could have foreseen, yeah, this will mushroom into a bigger thing, but I think that it was really more of a this is what we need to do today kind of approach.
Yeah, and I think I would second that. I think we were merely reacting to the assertions that Microsoft made to us, and our entire goal was to level the playing field and walk away without paying Microsoft, or maybe Microsoft would pay us since they had a lot more products for sale and more profitable than we were. That was the goal, and this litigation, it was obviously Microsoft's idea that we reacted to. There was other litigation filed all over the world where we were pursuing patent infringement against Microsoft and their products, but this one was just, we were reacting.
Okay.
So I want to ask this question first in maybe
Sure. So I think, you know, the letter in and of itself, maybe it could have been refined somewhat, but I think the most of what I learned from the case was more around, you know, with Judge Robart's guidance with respect to the value of the standard to the products, studying that and having data to support it, the value of the patents to the standard, and doing more of that. Obviously, we were reacting to a lawsuit that had a very short time frame, so we were hurrying. I think maybe some of the words could be changed, but making an opening offer is what you need to do. And you know, the ZTE Huawei case in the European courts lay out a whole process of you need to make an offer, they need to respond, you have to do these things. So I don't think the letter in and of itself was terrible. You know, the rate ended up, you know, it looked like a large number, but it was based on our historical licensing practices, so it didn't seem way out of line. You know, the result looks way out of line after the FRAN rate is determined in the court, and it's much, much different. But I think I don't see a lot of different. Maybe there could have been some words that indicated this is more of an opening offer or something, as opposed to Microsoft interpreting it as a demand. It's a good question.
Yeah, so I don't disagree with that, with Kirk's comment. Maybe for me, if you could sort of extract out of this a strategic conclusion about standard essential patents in this context, I think the conclusion is that maybe standard essential patents, because they come with baggage, they come with this notion that the value really has to do with the collaborative process rather than the value of the particular innovation. That because the standard essential patent comes with that type of baggage, maybe it should be taken out of the arsenal of strategic choices that you make when you are in a negotiation posture with another company. Motorola has thousands of non-standard essential patents. All companies that are in the technology area do lots of research. They have lots of great technology. And so maybe if you're going to go to your patent arsenal and try to pull something out that might be strategic, you should not go the standard essential patent route at all, but use your other patents. And there, you may seek an injunction. You can do whatever the law entitles you to do, but maybe avoid this area.
So it's interesting. So I'll just comment on that from that perspective. So I think in a more less time-intensive scenario, where if Microsoft came to us and wanted to negotiate, and we had time to respond to that, because when you take the time and effort to map, you know, your thousands of patents that you have relevant to Microsoft that you're not really targeting for any particular reason, it takes time, it takes money, it takes a lot of, you need a lot of resources to figure out what patents in your 24,000 patents that Motorola had at the time apply to Microsoft's devices. So maybe you're right, and we did use non-essential patents, but we were under the, from a larger litigation perspective, we had received multiple litigations from Microsoft filed everywhere, and it's really a race to judgment. And so you can't wait 6 months to decide what you're going to sue Microsoft on. It's a matter of days or weeks. And so that's why we had the short time frame for a response, so that we could put them on the table. Yeah, maybe it's not ideal to use SCPs, but we felt like, you know, that was part of our arsenal that we had to use, and it was already mapped out and it was ready to go. So,
Cindy, what lessons do you think we can take from this strategically?
I think it's an excellent question, and it's a question I rhetorically posed to my class on Wednesday because I don't actually really have a good answer. And I guess what I would come back to is the judge and I were talking about this question this morning, and he mentioned the importance of comparable licenses. And I know that both sides presented comparable licenses to support their stances in the case, and they were wildly different in the licensing rate that they came up with. But I guess back to sort of Andy's point, the comparable licenses really need to be about standard essential patents and only standard essential patents. And I don't know if they exist, but when you're coming up with that rate, you probably really need to have in your arsenal some comparable licenses to immediately show to the judge and say, this is fair because here are the licenses. You know, and I have the data to prove it. But that is very, I guess, Pollyanna-esque, because what is a comparable license ever? You know, could you ever have a perfect license?
Yeah. And I'll just, I think that's right. It's difficult because Motorola had a lot of what I would say are comparable licenses with the 2.25% rate in them. The problem is more of a practical problem, which is whenever you're having a licensing discussion with someone, they don't just want a license to your 50 essential patents when you have 24,000. They're willing to pay you for those 50 patents, but they want a license to everything that they're using so they don't have to see you again. And so almost every license is going to have some element of additional patents, different standards. You know, in the case of BlackBerry, they were using cellular, they were using Wi-Fi, they were using HSAT 264. They weren't going to just pay for a license for one. And so, you know, maybe you could construct a licensing regime where you have separate prices for each standard and there's clean agreements, but it's not really how, it's hard, it's difficult, I think, to do.
So one of the things that I think of when I think of the post-Motorola legal landscape is that Motorola sort of stands for a proposition that the FRAND issue can be litigated through sort of a contract lens, right? So it's a contract dispute at its heart. Part of that is the way it arose, right? But it also sort of has that flavor where you're really, you know, there's this issue of the SSO agreement being a third-party enforceable agreement. There's this issue of whether then the negotiation process involved in the give and take is reasonable. There are other FRAND cases that are just patent cases, right? They're just patent cases that have an overlay of reasonableness attached to them. What do you guys think about what's the right way to think about the post-Motorola and even maybe going forward landscape, about whether these are better litigated through a contract sort of lens like in Motorola, or, you know, the Ericsson and on some of the other cases which are really just patent cases where the patents may be encumbered, but they're nonetheless more traditional patent cases?
So, sure. So, good question. Yeah, so my view there is that what dominates really in a standard essential patent context is not the types of things that dominate in a typical patent case that's not an SEP patent case. And that typical patent case, what you're litigating over is the patent valid and is there infringement? And then what you might get to, if all of that is determined, is what are the damages. In a standard essential patent, when you have companies like Motorola or Qualcomm or Ericsson with thousands of patents, it's not really, at the end of the day, is there infringement, because the companies are practicing the standard. So you know there's infringement. There are so many patents, and all of these companies participated in the process of building the standard. So they built the standard, and the likelihood that anybody had ever done this particular specification exactly that way before is pretty low, so they're going to likely be valid. So the validity issues and the infringement issues that are your typical patent case, they clearly take a backseat. What becomes important is, well, what's the value? How do you determine the value? And that's what happened in Motorola v. Microsoft. We agreed, actually, and this is how we differed, I think, strategically from Apple. On this point, we agreed we'll take the license. So just tell us what it is, and we'll take it. So we put the classic issues aside and said, let's just deal with the value. I think the best way to deal with the value, frankly, is either a contract case, and then depending on the facts, you could approach it from a competition law perspective. But I do think that's what gets at the heart of what makes these patents different, and the litigation of these patents different from a more typical case.
Kirk, any thoughts or agree?
You know, it's kind of funny. I mean, my answer is a little bit different. Mine is, I would avoid litigation and try to settle it through reasonable negotiations, because no matter which approach you take, things get distorted in judicial remedies, right?
Somebody
And so
else is
it's
ultimately deciding.
Yeah, and I think all the issues are important. I mean, it just depends on your defense. I mean, some people are, you know, very, like you referred to Apple, you know, people want to talk about infringement and validity, and it's important, and maybe damages are more settled, and so it's not as big of an issue. It's all fact dependent. I think it's hard to say.
Okay, good. Gentleman out there, yep. So introduce yourself and then ask your question.
So I think, you know, what happened between ultimately Google and Microsoft is confidential, but there was no discussion between the time we sent the letter and the time that Microsoft filed the lawsuit. We didn't have any conversation. After it was filed, there were all kinds of settlement discussions, but I don't recall a lot of discussion on that particular issue.
Yeah, so I think that's right. I think that getting to the question of the methodology, so how do you end up with a rate? I think you framed it pretty well. I think the approach that Motorola had taken, and was again, it was a standard approach. It wasn't the first time, and in our case, was to have a percentage applied to the end user product. So during the trial, during the case, we came up with an alternative approach, which in our case, we did in a way sort of embrace this notion of comparables, but what we pointed to as what would be a good comparable would be the patent pool universe. So in a patent pool group of companies get together, they pool their patents, and then there is typically an administrator, and then you administer the patent pool by people can come to the pool and then get a license, and then pretty much everybody gets the same license rate. It may vary based on industry that they're from, but you get a rate for the patent, and it's administered in, rather than a one-off negotiated way, one person negotiating with another person. It's more of a multilateral approach where there is a pool rate that's made available to everyone. And so that's ultimately the way we sort of approached it. The patent pools were not a perfect comparable for reasons that that come out in the opinion, but I think it is an alternative approach to this. And it may be a particularly useful approach when you factor in the non-discriminatory aspect of FRAND. So our case with Motorola dealt with the first part of FRAND, reasonable. Is this a reasonable license? And an aspect of the case that we never really addressed, but that is actually now addressed in this TCL opinion that Judge Robart mentioned, and a maybe more important aspect is non-discriminatory. So the rate that has to be offered has to be reasonable and non-discriminatory, and what does that mean when you have similarly situated licensees? And I think that non-discriminatory prong maybe eliminates the ability to look at these cases in a one-off bilateral negotiation context, because you can't combine the two. You can't have a universally non-discriminatory rate and a unique rate for every single licensee based on that licensee's negotiation. I think TCL is Judge Robart talked about the evolution. I think that's the evolution of this area. It will take you exactly to that point in terms of a methodology.
Yeah, and I'll just comment on that quickly. So I now work at the Marconi Group, and one of the companies that's associated with us is Voluntary, and it's trying to do exactly that, which is we have a platform, licensing platform with a published price, and it's taking 2, 3, and 4G technologies, and when you're applying it into the Internet of Things, you're making it available all the same price for those people, because you have hundreds, if not thousands, of implementers all over the world that are using the technology, and they just want to know how much does it cost, and how can I build this into my bill of materials so I can build a product. I don't really want to negotiate with the 15 different patent holders for each standard and negotiate those things. I don't have the resources or the time or the patience. So that's what we're trying to do, and we get away. I think it's important. There's always camps of the smallest saleable patentable unit versus the entire market value rules. We just need to find a fair price that people are willing to accept, both from an implementer perspective and an innovator perspective, and that's what we focus on, and it's more of a pragmatic approach. I think there's other, it can be just a pure patent counting exercise, which many platforms and pools end up with because there's too many patents to deal with. But there's other people, I think, that can live with FRAND, but maybe they have, as Judge Robart said, a more important set of patents, or more, they invented a bigger portion, or their patents have more value, and therefore they're entitled to incrementally more value on a per patent basis than others.
Mike.
So first for Kirk, I'm wondering if the 2% rate that you asked for elsewhere also applies in standardized cases. It seems like in this case there are so many standards in the product, so many patents in the standards, that this quickly could be higher than the cost of the overall product. So I'm wondering if this applies elsewhere in other standardized contexts, and if the panel does a top-down approach that's added to the bottom-up approach of the case, helpful, where you have an alternate tax. You say, here are profits, you get some percentage of that as royalties, you get some percentage of that as 10% of tax. You can't ask for more than the actual cost of the product, because top-down puts a limit on that. And then finally, to Andy, in terms of non-discrimination in the CCL case, what the court there seems like the right answer. You look at all the global actors, you say if Apple and Samsung are getting a good rate, you all should get a good rate as well, and how do we decide not to?
Those are very, there was a lot of questions there. Let me see if I can dissect a couple of them. I think, I think, let me see, what was the first question?
Is 2% other applying other?
Yeah, I haven't seen, there's been a lot of discussions of royalty stacking, and will put people out of business. They won't be able to develop products, and especially in the telecom space. And you know, the fact of the matter is that's been discussed for 20 years, and there's 1.8 billion, 2 billion units manufactured and sold every year. So the market's quite profitable and working quite well. So, you know, I haven't seen royalty stacking prevent business from functioning, and they find solutions. I think the top-down approaches that we've seen in Huawei UP and also the recent TCL case, they're interesting, but they're very different as well, right? So it provides some guidance, but you know, it doesn't really provide an answer, because one has a royalty. You know, nobody knows how many SCP patents are really relevant and valid and infringed in a particular technology. It's really hard question, and I think TCL was a base of 1,400 patents, and the other one was 800 patents, and they had different royalty rates. So it's hard to. It's a guidepost, but I think it's very fact dependent. And I don't, you know, you can use some analysis. If we all knew what the top-down analysis was and we agreed to it, then maybe it would work. And that's what we try to do, because we introduced a platform where it's $15 for an automobile using this, and then we have formulas that we use to decide what your distribution is. So we kind of do it in a private way to help people deal with that issue.
So just real quickly on top-down, bottom-up, I think that those are two labels that are given way too much significance. I don't think that any of these methodologies really lend themselves to that precise labeling. Both, to the extent that they're even two different approaches, they're really, the goal is to get to a reasonable royalty. And there are different ways you can get there. What makes sense about the top-down approach is if the royalty has to be reasonable in light of the overall cost of the product, then it makes sense to look at it with an aggregate royalty context. And especially in that TCL case, one of the things that Judge Selna pointed out was that Ericsson was in competition to get its particular approach adopted. So Ericsson was a champion of LTE. It was in competition with UMB. It was in competition with WiMAX. So Ericsson goes public and says, look you should adopt what we're doing, and once you do, not to worry about the price, because there's going to be an aggregate royalty attached to this, and you're not going to pay probably more than 6%. So don't worry about the ultimate price, and you should adopt LTE as the standard. They adopted LTE as the standard. It really then, I think, becomes difficult for Ericsson to walk away from that aggregate royalty or top-down approach. I think they're, as Judge Selna found, I think maybe they're a little bit stuck with that at this point. On the question of discrimination, I think that is a really interesting issue that's going to come up in the appeal of TCL, and it gets you closer, I think, to the competition law aspects of this case. One of the big issues is in a market that's really dominated in many ways by two companies. In this particular market, you've got Apple, you've got Samsung, and then you've got everybody else in a way. In a market of that sort, for these sorts of patents, I think the question is, should Apple and Samsung be given lower rates than everybody else? And if the answer is, yeah, they get a lower rate, then the impact of that from a competition point of view, I think, is pretty harsh, because if you're a new entrant in the field, you're right off the bat, you have to pay a higher cost for your good than the guys that are already dominant, and everybody, it has such an entrenched hold on the market. So I think that Judge Selna's approach to discriminatory, there's a lot there that lends itself to his approach, whereby he says, no, you can't really offer those guys a sweetheart deal because that has an impact that goes against what Etsy was trying to achieve. Etsy was concerned with stuff like that, and if you give these guys the lower rate, then that wouldn't achieve the goals that Etsy was trying to achieve. So I think you're going to end up with it, no, other people ought to get that same rate. Once you end up there, where people are getting the same rate, then the entirety of that negotiation model it now gets challenged, because how do you negotiate individual rates when everybody's supposed to get the same rate? So I think that's where we're headed going forward.
Excellent. All right, so we have reached the end of panel number 1. We have a bit of a break, about 15-minute break before panel 2 starts up around 4. Are there refreshments right behind? Behind the wall? So, and thank you to what's clearly the best panel of the entire afternoon.